The America's Democrats podcast, a project of 21st Century Democrats, is made possible by contributions from our listeners. Want to do more? Go to americasdemocrats.org and click Donate. And thank you for allowing us to be your voice. And if you enjoy the show, please share it with your friends on Facebook and Twitter, and leave us a review on your favorite podcast app. This is the America's Democrats podcast, the weekly podcast for stand-up Democrats. I'm your host, Jim Cuddy. This week, elections expert Amel Ahmed makes the case for voting as a positive right. Author John F. Kowal on how people have made our Constitution more democratic. Plus Bill Press with NBC News Justice Correspondent Pete Williams. Had enough of Fox News, the House Freedom Caucus, and Donald Trump? If you want the facts that you won't get from them or from the fake news sites of the alt-right, then stay tuned. Our sponsor, 21st Century Democrats, works hard to get everyday Democrats involved in returning our party to its roots and to success at the ballot box. Sit back and listen, then stand up and fight. And follow 21st Century Democrats on Facebook for all the latest progressive news. We're glad you can join us. The passage of H.R. 1 would mark a necessary advance in defense of the right to vote. But does that go far enough? Amel Ahmed says more can be done to go on the offense in the struggle over voting rights. And we say hello to Amel Ahmed, an associate professor of political science at the University of Massachusetts Amherst and author of Democracy and the Politics of Electoral System Choice, Engineering Electoral Dominance. Amel Ahmed, thank you so much for joining us today on the America's Democrats podcast.
Thank you for having me.
Our pleasure to have you with us. And Amel, you recently wrote a piece for the Washington Monthly titled Why We Should Rethink Voting Rights from the Ground Up. And you point out that we tend to think about voting rights as a negative right. What does that mean, and what makes it, as you describe, faulty?
Well, I think thinking of voting rights as a negative right essentially puts us in the framework of protection from harm. And those are the kinds of demands we make of the state to protect us from harm in exercising our right to vote. And it comes down to protection from intimidation, obstruction, and all those things that would make the franchise less equal. And that's, of course, really important. But in that piece, what I'm trying to do is trying to reimagine what it would look like if we thought of voting rights as a positive right. And that would take us away from protection from harm and put us more in the framework of making demands on the state that empower us with the resources we need to secure our well-being. So it makes it, more of an affirmative right to vote. And I think that's something that is very much lacking in how we approach voting rights in the US. And I think that has a lot to do with how voting rights have evolved. We have no right to vote within the Constitution. That has never been the case. There have been attempts to establish it, but they've not been successful. And subsequent efforts to assert a right to vote have usually referred back to the Equal Protection Clause. And so again, that's really making demands that the state protects us from discrimination, making sure that we have equal access to the franchise. But it really is silent on whether or not we are actually able to exercise that right. And so that is what I am hoping to do by moving this into a different framework where we think of it as an affirmative right. And we think of the state as providing for our welfare rather than just protecting us from harm.
And you would think that would be something that everyone could agree on, and sadly, it's not. In fact, you argue that a truly progressive agenda would treat voting rights like economic rights. So what's the benefit in this approach?
I really like economic rights as a framework for many reasons. Number one, because economic rights are also not guaranteed in the Constitution. But it gives us a model for how something that we don't have any, constitutional guarantee for, we can still make these demands. And it really, economic rights have been hard fought, hard won through advocacy, through mobilization, social movements that have increasingly made clear the costs of not having these rights and built up a consensus that this is something that we are owed just as a condition of human welfare. And given how important voting rights are, I think we can also shift to a similar framework. I think, I also appreciate the economic rights framework because it thought in terms of how to bind politicians to specific outcomes and not rely on their own sense of fairness and political efficacy. And I think that's a really important way to approach this. There are many principled politicians who are committed to voting rights advocacy and the protection of rights. But to my mind, that is not a stable basis for something that's so essential to our democracy.
Mm-hmm. And right now, voting rights advocates are pushing for the passage of H.R. 1, the For the People Act, as a way to protect elections. What do you see as the limits and possibilities of this act when it comes to an affirmative right to vote?
Well, I'll say, first of all, H.R. 1 is a kind of massive, sprawling bill with lots of things within it. Many of those things still are within the framework of negative liberty. And, the negative rights are important. Protection from harm, protection from discrimination are still critically important. So that's a part of H.R. 1. But it goes beyond this, I think, in really useful ways. So provisions such as introducing automatic voter registration, secure mail-in voting. And there are many tweaks to election administration. They seem like minor tweaks, but they actually really help improve and streamline in-person voting. And so, when you think of this as a positive right, I actually think of really concrete, mundane things. I think through my own day. I think through, elections that come and go. And I'm someone who is very well versed in electoral politics and in voting rights. And it's hard for me to keep up. It's hard for me to integrate it in my daily activities. And I'm constantly surprised that, local elections, which are critically important, it's hard to get information about what's happening. It's hard to even keep track of the deadlines and registration. And there are lots of things about voting that are complicated and confusing, even if you're paying attention. And so I think of this really in very concrete terms, how to make it easier for people to get the information they need and to get out there and really execute that right that they have in reserve. I think one of the major limits of H.R. 1 is that, I think the framing doesn't give us a sense of why all of these things are coming together. And that's been a limitation. It seems like, a whole, array of things that I think it's been described as a wish list for voting rights advocates. But it really shouldn't be. If we can understand it in terms of what is required for voting rights as a positive right, it makes a lot more sense why these things are being brought together. And so I think it's really important that we consider what's happening at the level of political imagination. In addition to the practicalities and the logistics, people need to be able to make sense of why these things are being brought together. And I hope that we can articulate this more clearly as a push for an affirmative right to vote, not just the defensive posture that we often take.
Mm-hmm. You mentioned as H.R. 1 is this massive bill with all sorts of things about it. Does it make sense, or is it maybe this the only way to get any sort of election protections passed? But does it make sense to then just do a standalone all by itself? Here's what we have to do: streamline how people have the right and get to vote, or is that an impossible task given how so many people seem to be against letting people have an easy way to vote?
I think I would absolutely. That would, in my mind, be progress if we could just figure that out. But one of the biggest challenges for the US is that our election administration is so very decentralized. So even streamlining that process is, that would require its own 700-page bill. So there are things that unless we're willing to establish some kind of agency that's paying attention to this, it's going to be very difficult. And we really don't have a central agency that's managing this. We approach voting as this kind of laissez-faire enterprise where different localities are managing it in different ways, and different individuals are responsible for providing their own information, collecting their own resources, and figuring out how they're going to get to the polls. And so, one of the things that really struck me in the past presidential election 2020 is how much we did to help facilitate voting given the conditions of the pandemic. And it made clear how much support people need on a regular basis. So we did it because the pandemic presented all of these obstacles. But I think that is a model for us going forward, not just for the pandemic, but for all times, because it made clear just people need a lot of support to do this. Even knowledgeable people who are paying attention and care about this and want to, exercise their civic liberties. People need support. And I think that's a model for how we can move forward with it.
We're speaking to Amel Ahmed, an associate professor of political science at the University of Massachusetts Amherst and author of Democracy and the Politics of Electoral System Choice, Engineering Electoral Dominance. Amel, if government were to take an aggressive approach to affirming the right to vote, what would that entail?
So I think there's a lot that could be done to make to take a more aggressive approach. But I will give you just one that I would start with, and I think this would be critical. I would start with giving people time off to vote. I think this is a structural feature that makes very clear how much of a laissez-faire approach to voting we have. People have to carve out their own time before work, after work, during work. It's managed privately. It's managed by each individual according to their own ability. It should not require that much work. So require employers to give people time off to vote. They are not required to vote, but if they choose to do so, they should have the time off to vote. And I think in addition to removing the logistical obstacle, this one change, and it would be a significant change, but it does so much more, because I think it helps to signal to people that this is an event and it's an activity. It's a reminder we have time off to vote. It's a reminder that this is happening. And more than anything, it makes voting more of a communal act, which I think has become less and less the case. It's become more of an individual activity, a private activity, and less of a public event. And so I would love to see legislation that required employers to give employees time off to vote.
Mm-hmm. You specifically highlight the work of Stacey Abrams. Why did you choose to focus on her?
I think, I recalled hearing interviews that she had done, and I remember thinking how lucidly she combined the framework of voting rights advocacy with the framework of mobilization. And that to me is really just the perfect marriage, that there is no voting rights advocacy without thinking through mobilization in terms of how to empower people, how to get them there, not just remove obstacles, but how to get them there. And it's not just her. I think a lot of organizations, a lot of voting rights groups do this organically because they realize that it's an extension of what they do. But she made it very explicit. And she said, it's not enough to focus on discrimination. And I think it's absolutely right. It's not enough to just focus on discrimination. You have to help get people there. And I think it's important because there are nefarious obstacles that we know about that try to prevent people from getting to the polls. But beyond that, there are many obstacles that just exist naturally. Even where there's no concerted effort to deny access, the whole system seems to work to deny access, to put the cost of voting higher than it should be. When you think through what people have to figure out just to make sure that they're going to the right place and they're registered and they've done everything that they need to do, logistically it becomes very difficult. Now, I really value Stacey Abrams and the work she's doing, and her whole advocacy network was really impressive. But I think even that has its limitations. And this is why, again, I think of it in terms of rights. This can't fall to private advocacy groups. And increasingly, I think it falls not just to the advocacy groups, but to political parties are in charge of that kind of mobilization. Historically, we've had lots of groups that were involved in that kind of mobilization. We've had labor unions, we've had religious establishments, we've had all sorts of groups that were involved in facilitating mobilization and helping people get to the polls. As those institutions have atrophied, we rely more and more on parties, sometimes these advocacy groups, but their reach is rather limited. So most of the mobilization that takes place is taking place through parties, and more specifically through campaigns, where it's very strategic and very limited. And there are many people who are never going to have anyone knock on their door or give them a phone call to remind them to vote. I don't think this can be entrusted either to private advocacy groups or to campaigns.
Moving ahead, where else do you see the efforts taking place, and who do you envision can be effective in moving us toward a more encompassing embrace of voting rights?
I think it's going to come down to social movements and whether or not we can build enough of a social movement. And this, again, I go back to the example of economic rights. It wasn't any single group. There are lots of lobby groups and advocacy groups that were involved in this, a lot of politicians, but it was really a coalition. And that coalition started with the idea that this needs to be a right and it has to be secured. And it doesn't matter if it's in the Constitution. I will say there are people who are pushing for a constitutional amendment, and I completely support that. But we don't need to wait for a constitutional amendment. I think it's really about changing the frame, and for all of us, changing our ideas of what we can demand of our government. And it begins with that initial step to say, we can demand more, and we don't have to just take this defensive posture and be on our heels. It can be more of an affirmative push. But I think it will take a social movement. I think it will take a coalition of politicians, activists, advocates, and everyday citizens saying this has to happen.
It's a shame that this is such an ongoing uphill battle. If why people have to try and restrict others from voting is beyond me, other than they don't believe they can win if they don't. And that's absolutely wrong.
I couldn't agree with you more. And I think it's those threats that keep us in this defensive posture, because there is a lot to defend against. That is absolutely for sure. But I think this is not a winning posture. I think if we really just keep playing defense, it's going to be at our own expense. And really, it's time to go on the offense, which is hard to imagine given everything that's happening. But it's time to really think more aggressively and more proactively about how we can think through this whole system and not keep finding ourselves in this same position over and over again. Throughout the past decades of U.S. history, voting rights advocates have found themselves in this same position of playing defense, litigating egregious acts piecemeal, focusing on individual cases because we don't have a framework to support the whole system. And so it seems like a tough time to be thinking of that when we're still playing defense on so many different fronts. But I think this is exactly the right time to be moving in that direction.
Absolutely. Amel Ahmed, Associate Professor of Political Science at the University of Massachusetts Amherst, author of Democracy and the Politics of Electoral System Choice, Engineering Electoral Dominance, joining us today on the America's Democrats podcast. Amel, we would love to have you back again with us soon.
Thank you very much. I would love that.
Thank you for your time. And this is the America's Democrats podcast, the weekly podcast for stand-up Democrats. We want you to sit back and listen to this americasdemocrats.org podcast, a project of 21st Century Democrats. But we need you to stand up and fight. Do you want to get involved and help get our party back to its roots and to success at the ballot box? You can make your contribution to help us keep this show going and to elect Democrats who will stand up for democratic principles. Go to americasdemocrats.org and click on Donate at the top of the page.
This Social Security measure, I believe that we must pass legislation to provide medical care.
This is our tradition. When our grandparents came to America, it was the Democratic Party which said, welcome. It was the Democratic Party, the party of Roosevelt and Truman and Kennedy and others, who said that America belonged to all its people, not just a handful of the rich or a few giant corporations. That's why great leaders like FDR fought so hard for Social Security, and why JFK stood up to the insurance companies and their Republican allies to get Medicare. It's not just one thing, or one time, in one place. It's about a whole history of standing up to the Republicans and saying someone has to be on the side of regular working people in America, whether it's defending Social Security or just the way your loved ones are treated on the job. That's what the Democratic Party is all about. And that's why this message has been brought to you by the Democratic Party. Working people like you and me.
Paid for by 21st Century Democrats. Not authorized by any candidate or candidates committee. This is the America's Democrats podcast, the weekly podcast for stand-up Democrats. Coming up next, who really wrote the Constitution? But first we turn to Jim Hightower, America's #1 populist, for his common sense commentary.
Question: what does a packet of M&Ms and your local veterinarian have in common? Answer: both are owned by Mars Inc., the global candy monopolist. Since the 1980s, we've seen massive consolidations in industry after industry, from airlines to newspapers, the internet to candy. These monopolists run roughshod over consumers, workers, communities, suppliers, and our nation's commitment to the common good. And now the corporate attitude seems to be, what the hell, why not let monopolization go to the dogs? This change has been led by private equity groups. They are corporate takeover sharks that borrow billions of dollars to buy out, plunder, then sell off the remnants of established businesses. They target enterprises that can be grabbed on the cheap but have assets like a loyal customer base. Then, the sharks raise prices on those customers while cutting staff and quality of service. This has been happening to thousands of local vet practices and hospitals, which have quietly been plucked by Wall Street entities bearing nondescript acronyms like IVC, JAB, KKR, and VCA. At first, locals don't notice the takeover because the corporate outfit not only buys your friendly Dr. Barry Bones vet service, but they also buy the doc's name. As an IVC takeover consultant confided, people like to take their dogs to local vets and not feel like it's a corporate machine. But increasingly, it is. Solo practitioners now must answer to bean counters at headquarters, such as VCA, Veterinary Center of America, which has 1,000 vet practices across the country and is now owned by Mars, Inc. This is Jim Hightower saying one feisty group battling monopolizers is the National Veterinary Professionals Union. Get info at natvup.org. Howdy-ho, folks. Thanks for tuning in and sharing my weekly commentaries. Also, please join me for a live web show I host every other Tuesday, the Hightower Lowdown Happy Hour at the Chat and Chew Cafe. You can join the action live online as I chat with grassroots leaders and progressive sparklies from around the country. Go to hightowerlowdown.org/chat-and-chew to find out about upcoming guests and watch past episodes. That's hightowerlowdown.org/chat-and-chew.
This is the America's Democrats podcast, the weekly podcast for stand-up Democrats. In his new book, co-author John Kowal tells the story of how 200 years of constitutional amendments have made our founding document more inclusive and more democratic. It's a history, he says, with great relevance for today. And we say hello to John Kowal, Brennan Center's Vice President for Programs responsible for guiding the organization's democracy, justice, and liberty and national security programs. He also manages the Brennan Center's Fellows Program, and he is recently the co-author with Wilfred Codrington III of The People's Constitution, 200 Years, 27 Amendments, and the Promise of a More Perfect Union. John Kowal, thanks so much for joining us today on the America's Democrats podcast.
Jim, it's wonderful to be here. Thank you for having me.
Certainly our pleasure to have you with us. So the process of amending the Constitution was codified from the very beginning by the framers in Article 5. What is your sense of why they included Article 5?
Well, to understand that, you need to go back to the story of why we have this Constitution. Our current Constitution is not the first. For 8 years, America lived under a different Constitution called the Articles of Confederation. And the Articles authorized a very weak national government and left most powers to the states. It was there are still states' rights people today who think, oh, that was the ideal. But it became very clear that the lack of power to tax, and other powers was a problem. So they wanted to amend the Articles to give the government more power. But there was a big problem that the Articles required the approval of every state to amend the Articles. And every time they tried, one state, it was often Rhode Island, would say no because they were looking out for their own narrow interest. And it was this paralysis because they couldn't fix the Articles of Confederation. That was a very big reason that the framers met in Philadelphia to draft an entirely new constitution. So that's why we have a more robust amending procedure called Article 5.
Is it reasonable to say the framers intentionally made the amendment process difficult? I mean, and if so, what would be the logic in that?
Yeah, well, when you look at the records of the Philadelphia Convention, one frustrating thing is that they don't spend a lot of time talking about the amending procedure. You do see a number of the framers talk about the need for an easy and regular way of amending the Constitution. But again, they didn't spend much time debating it. What seems clear to us is that on the one hand, they knew that they needed a procedure that would make the Constitution flexible enough to meet the needs of a changing country over time. But on the other hand, the Constitution was the product of many hard-fought compromises. And so they equally wanted to make sure that they were locking in those changes and they wouldn't be changed too easily. In the Federalist Papers, James Madison tried to sugarcoat it, describing it as an ideal balance between a Constitution that was what he called too mutable and one that would only perpetuate its discovered faults.
So how hard is it to amend the Constitution?
In their wisdom, the framers set up a process, a complicated process that requires winning supermajority support twice. So the way we amend the Constitution is in two steps. First, an amendment is proposed, and they set up two ways of doing that. Congress can propose an amendment with 2/3 majority support. I mean, it's happened in the past, but obviously a 2/3 vote sounds like a very high bar today. There's a second procedure that's never been used that would allow 2/3 of the states to ask Congress to call a convention, and the convention would propose an amendment. That has never happened in our history, but there are groups even today on the far right trying to call one of these, and we can get into that. The second step is ratifying the amendment, and the amendments are ratified by 3/4 of the states, another supermajority bar that can either be done by the state legislatures or Congress can specify that each state call a convention to vote the amendment up or down. That happened once when Congress wanted to fast track the repeal of prohibition, which was a huge problem for them. They went this route with conventions. It's obviously a very difficult process. And yet, as our book explains, history shows that what seems impossible can sometimes become very possible in short periods of time.
And we're speaking to John Kowal, Brennan Center's Vice President for Programs, responsible for guiding the organization's democracy, justice, and liberty and national security programs. He also manages the Brennan Center's Fellows Program and, most recently, the co-author with Wilfred Codrington III of The People's Constitution, 200 Years, 27 Amendments, and the Promise of a More Perfect Union. And, John, hard as it is, at least 11,000 amendments have been proposed since 1789, and as the title of the book points out, 27 succeeded. When you look across those 27, what kind of themes emerge in the way they have changed our nation?
So in the book, we tell the story of 4 waves of changes to the Constitution. And these waves are punctuated by decades where change feels impossible. But the 4 waves of amendment have made the Constitution more democratic, more inclusive, and more suited to the needs of changing times. And so in the period immediately after the adoption of the Constitution, the founding era, we see a focus on making sure that the newly created stronger national government is tempered by protection for individual rights. And that is, the adoption of the Bill of Rights. After another 6 decades after the Civil War, we see 3 amendments passed after the Civil War with a strong focus on equality, which is a word or a concept not even included in the original Constitution. So in 3 amendments, we fixed the original sin of slavery. We guaranteed equal citizenship to 4 million freed African-American slaves, and we protected voting rights. And it was the first of 5 amendments to protect voting rights. These changes were so profound, mostly because for the first time, the Constitution could be used to limit the abuses of state governments and not just the federal government, that we call it America's second founding. And then in another half a century, in the progressive era of the early 20th century, you see a different focus on modernization and progressive reform. We introduced the income tax. We provided for the direct election of senators, giving people this power instead of state legislatures. We also see 2 major social movements of the 19th century, women's suffrage and prohibition, on temperance, yield great successes in the passage of the 19th and 18th Amendments. And then in the civil rights era of the 1960s, we see how that era's civil rights movements and social movements led to 3 more voting rights amendments that included youth, that included the residents of the District of Columbia, and there was also the nearly successful attempt to protect women's rights in the Constitution through the ERA.
And John, what can you tell us about the people who fought for these changes? I mean, how did they impress you?
So when we look at the book, one thing I really learned was, number one, how individuals working through social movements have sometimes made the decision, sometimes because there was no other option, that going down the long, hard road of winning a constitutional amendment was the way to success. And so I'm impressed by the women's suffrage leaders like Susan B. Anthony, who committed to essentially 4 decades of advocacy to win the 19th Amendment. It sounds like a not efficient investment of time, but in fact, in the meantime, they were working to win in the states, and in 4 decades, they got 4 states to agree to extend the vote to women. They just understood that they needed to be tenacious and fight, and you just can read in newspapers and in congressional testimony how they were at it, and they just kept going until their moment finally came. I'm also struck by the sometimes political insiders have been the champion of amendments, again, with great perseverance and patience, whether it's James Madison, who understood at the founding of our country that there was a split in our country, the people who welcomed the new strong national government and people who feared that there would be a tyrannical government under it. And he understood that by adding the Bill of Rights, something that he never thought was important, that it could be a signal to the rest of the country to embrace the new Constitution. He had very few people willing to help him, but he, through his own perseverance, got those amendments through. I also, I guess I'm struck by the people who work in the civil society sector who made a big difference. So Alice Paul, who was a latecomer to the women's suffrage movement, younger than a lot of in fact, some of the first generation died because it took so long, but she had a media savvy and she had worked with, radical suffragists in London. And so coming on the scene, she did more than, to really get media attention. She organized a march of suffragists that turned into a really awful riot, but the martyrdom of these women who were suffered at the hands of male onlookers gained them invaluable media attention. Sometimes one person can also block an amendment, and so we tell the story of Phyllis Schlafly, who really took intervened during a time when the Equal Rights Amendment looked like it was on a glide path to victory, organized an opposition, became the face of blocking an amendment. So there's a lot of interesting stories in the book. One reason that I think it would be interesting to your listenership is that we do make it about the people, and how they talked about the issue, how they overcame obstacles. And it's ultimately a story of how individual people and people organized in social movements make legal change happen.
Why is this an important book for this political moment?
So we have the most conservative Supreme Court in a century. And when you read the book, you'll see that a century ago, that Supreme Court was an obstacle to all kinds of progressive change. And I think we're heading in that direction again. And they're going to do it with arguments about the original meaning of the Constitution. But it's really important when people talk about the history and meaning of the Constitution that we don't just focus on the 55 men in powdered wigs who met in 1787, because that was not the end of the story. That was only the first chapter in a much longer story. The story of the Constitution and the meaning of a Constitution that was changed to protect rights, to become more inclusive, to include women and people of color, to become more democratic, is a remarkable story of progressive change. And the Constitution we have today is a far more progressive document than the one bequeathed to us by the framers. So it's really important that people understand the whole story and don't be taken in by the 1787, first chapter. I also think the Constitution is just too important to leave to the lawyers and the judges and the politicians. The framers intended that future generations, through democratic action, would make their imperfect Constitution better. And there's no reason why Americans today should throw up their hands or wring their hands. We have changed the Constitution through democratic action before, and we can do it again. And if history is a guide, these long periods where it feels difficult to amend the Constitution, and it's been 50 years since Congress last approved a successful amendment, eventually give way to maybe a decade's time when suddenly it is very possible to amend the Constitution. We believe that time is coming. It sounds crazy, but that this current era of gridlock and polarization will very likely give way at some point to a decisive election where for a brief period of time there is a new majority. And if there is the hard work of activists looking to make amendments happen, that's when change can happen in a short period of time.
John Kowal, Brennan Center's Vice President for Programs, responsible for guiding the organization's democracy, justice, and liberty and national security programs, joining us today on the America's Democrats podcast. Again, the title of the book, co-authored with Wilfred Codrington III, The People's Constitution, 200 Years, 27 Amendments, and the Promise of a More Perfect Union. We can only hope for that more perfect union. John, we appreciate your time with us today. Would love to have you back again soon.
Thank you so much. It was really enjoyable. Thank you.
Thank you. And this is the America's Democrats podcast, the weekly podcast for stand-up Democrats. We want you to sit back and listen, but we need you to stand up and fight. Help get our party back to its roots and to success at the ballot box. Make your contribution to keep the americasdemocrats.org podcast, a project of 21st Century Democrats, on the air, and help elect stand-up Democrats. Go to americasdemocrats.org and click on Donate at the top of the page. This is the America's Democrats podcast, the weekly podcast for stand-up Democrats. And now Bill Press talks with Pete Williams of NBC News on what to expect as the Supreme Court opens its momentous new term.
One thing that they settled before actually starting the new session, I guess, was a decision on D.C. statehood. This sort of kind of killed any chances for residents of D.C., like you and me, Pete, to have our vote count, didn't it?
Yeah, no big surprise here. The court just declined to take the case. It was one of thousands that piled up over the summer. The Supreme Court goes through what's called the summer list and issues an initial order list on the first Monday when they're back in session. And it was one of the cases they weren't going to take. But I don't think hopes were high, or hopes were high, but expectations were not high.
Right. And one of the cases they took last week, I found pretty unusual, and that is that this was a case regarding September 11, and an inmate down at Guantanamo Bay, considered the mastermind of September 11, Abu Zubaydah, having his day in court. What was the issue, and what did the court, how did the court handle it?
Well, this was actually one of the argued cases last Wednesday.
Right.
Abu Zubaydah, the first person, he was initially picked up by the CIA overseas. They suspected that he was in the leadership of Al Qaeda. That turned out not to be correct. But he was the first person to undergo what the Bush administration called enhanced interrogation, and what his lawyers say was torture. He was repeatedly, many, many times waterboarded. He was slapped around, put in a small box, confined under very harsh conditions.
How do we know that?
Well, we know that for several reasons. First of all, the U.S. Senate the Senate Intelligence Committee issued a report on his interrogation and his treatment that answered a lot of these questions. The two people who devised and helped to carry out the torture program, the two CIA contractors, have testified twice about it now, and one of them has actually written a book. So there's no mystery about what happened to him. What he wants to know is where and who was involved in that where. And let me explain.
Yeah.
After he was detained, he was held in what the CIA called two black sites, places overseas. And Abu Zubaydah's lawyers say one of those places was Poland, and they want to know a little more about what Polish officials were involved, whether they knew what the nature of the treatment was going to be. And so they want to assist Polish investigators, and therefore they want to question these two former CIA contractors. The U.S. government won't allow that. They say the it seems to be, you could argue, one of the worst kept secrets that one of these was in Poland. The European Court for Human Rights has so concluded, and former Polish officials have said so publicly that it was Poland. But nonetheless, the CIA director, Mike Pompeo, issued a court declaration saying, look, we told these countries where we were going to have these black sites that we would never reveal them. And so we're still not going to. And the fact that other people have said it doesn't make any difference. It would be a betrayal of trust for us to do that. And allowing him to question these two, allowing Abu Zubaydah to question these two contractors, even if the contractors don't say the name of the country or call it country green or country X, they're still assisting Polish investigators, and that implies that it was Poland. So therefore, we don't want them questioned by Abu Zubaydah. So they've asserted the state secrets privilege, and that's the issue before the Supreme Court, is whether the state secrets privilege can block this testimony.
And from what I read, the justices seem to be pretty skeptical, since this is, as you point out, no big secret, no big mystery, why the government is holding the line here. And a couple of the justices suggested a pretty unusual solution, correct?
Yes, three of them. Two of the liberals, Stephen Breyer and Sonia Sotomayor, and one of the conservative, Neil Gorsuch, said, well, there's one other guy who was there when he was tortured. Why don't you ask him? That's Abu Zubaydah. And the government lawyer who was arguing the case basically said, well, that's not my decision. And they said, well, get back to us on that.
I find it striking that one of the leading terrorists, certainly if not on September 11, would have his day in effect in front of the United States Supreme Court, which says something about our justice system, I think.
Yes,
right?
and of course, he's no longer considered to be somebody who had much of anything to do with 9/11, but he's sort of, he's just in sort of this permanent detention, and I think that's one of the things that the justices, especially Breyer, wanted to know is why is he still detained?
Now, of course, these were just sort of the foreplay, if you will, for the big cases that are coming before the court. Some major issues facing for a long time that the country's been dealing with on gun control, on the death penalty, on religious liberty, and on abortion. Let's talk about each of those to the extent that we know what the cases are all about and what we might expect. Pete, let's start with the gun control issue. As I understand it, this is a case out of New York City, correct?
Correct. New York State, actually. It's not just the city.
Yeah.
In 2008, in a case from here in Washington, the Supreme Court, for the first time in American history, said that the Second Amendment does provide an individual right. The question was always, well, it talks about militias. Is it a militia right or an individual right? The court said it's an individual right to have a gun at home for self-defense. But since then, they've consistently ducked the follow-on obvious question. Well, what about outside the house? The Second Amendment says it's a right to keep and bear arms. So what about that and bear arms part? The case from New York raises that question. New York has a state law that says you cannot carry openly a gun in New York State. You can get a permit to carry a gun with a concealed permit. You can carry a concealed weapon. To get that permit, you have to show some special need for a gun, something beyond just a general desire for self-defense. And the question is, does that violate the Second Amendment? It's a New York Rifle and Pistol Association, which is the NRA affiliate in New York. They're the one challenging the law. New York is defending the law. And New York says, look, if you go back in history, there are lots of historical precedents for states restricting concealed carry. And even in the 2008 decision, the case called Heller, the Supreme Court said that the Second Amendment right is not absolute, that there are lots of places where you could restrict carrying guns into churches or schools and so forth. So this is the follow-on question that the court has turned away dozens of times and has finally agreed to take up, presumably because the conservatives in the past never knew where Anthony Kennedy would be. And I think now they feel that they probably have a majority on this question.
And by the way, that earlier decision where the court said that that the Second Amendment is not absolute, that was written by Antonin Scalia, correct?
Yes, and the theory is, I think the widely accepted theory is that In order to get a majority, he had to include that other language in there to get the necessary votes.
Right.
But nonetheless, you're right. It's his opinion.
Yeah, which is striking that it would be such the conservative justice with that opinion. Pete, hasn't this already been concealed carry question decided in other states?
Yes, but there's a split among the circuits. The circuits are divided over this. Some have said, under Heller's logic, there is no Second Amendment right to have a concealed carry, that states can put these more strict restrictions on. They can't ban it altogether, but these restrictions, especially in big cities, make sense. And other circuits, including some both liberal and conservative judges, have said, no, what does "and bear arms" mean if it doesn't mean carrying the gun outside the house?
Do we know when this case will be argued before the court?
Yes, November 3rd.
Mm-hmm. So coming up pretty soon. And I guess a question I should have begun with is, how do the justices decide which cases they're going to hear anyway? I mean, how did this case end up on the court's docket this year?
Sure. Well, it ended up on the court's docket because after the law was challenged by this New York Rifle and Pistol Association and a couple of people in New York who wanted to get permits and couldn't. So they went to court, they sued it, they lost in the lower courts, and now they're appealing to the Supreme Court. And how does this, what happens is, you have, if you go to federal court, you have a right, you have an absolute right to appeal the decision if you lose before the trial court.
Mm-hmm.
The appeals court must hear your case. After that, you have no right of appeal, but you can ask the Supreme Court to take your case. And the Supreme Court will decide whether or not to hear it. And it takes 4 votes of justices to grant a case, to decide to hear it. It takes 5 to win, obviously, but only 4 to grant the case. Now, I think you could safely say that the 4 are not going to vote to grant unless they think they have a 5th vote to win.
Right.
So that's one of the reasons. And generally speaking, the Supreme Court takes cases not to agree with the lower courts, but because they think about 2/3 of the cases they take, they reverse the lower courts. So the fact that there's 4 justices who think they're going to win here and they must have a 5th vote, and the fact that the court presumably took this to reverse the lower courts, is why I think this is probably going to be some kind of pro-gun rights ruling.
So as I hear you, the justices then are presented with a list, a rather long list probably, of possible cases.
Yeah, about 8,000 a year.
Wow. Out of which they choose?
About 65 to hear argument on.
Wow.
Some they decide on what's called summary judgment, just on the papers. But the arguments vary between 60 and 70.
Right. Well, they certainly were not ducking controversial issues this year.
No, not at all.
In addition to gun control.
Well, they did temporarily duck one. And I'll just throw it in here very quickly.
Go ahead, yeah.
This is a challenge to affirmative action in college admissions.
Mm-hmm.
It's a group of Asian Americans backed by a conservative who's pushed this issue for years. They're challenging Harvard's admissions program. They say that it discriminates against Asian Americans. And what happened last year is the Supreme Court solicited the views of the Solicitor General, meaning they want to know what the Biden administration thinks. And so that pushed it off. I can't imagine that the conservatives are sitting on the edge of their seats waiting to hear what the Biden administration thinks about affirmative action. I think that's just their way of saying, we've got enough on our plate. Let's hold this one off for later.
Right. Well, certainly affirmative action is not a new issue. Neither is religious liberty. Neither are school vouchers, moving to the next big case that we're expecting. God, I think I've been debating and talking about school vouchers ever since I started doing political commentary. This is a new case out of the state of Maine. What's the issue?
Right. Maine has a strange setup in this sense. Not every local school jurisdiction has a school. And if it doesn't, what it does is give money to the parents, and then they can use that money to send their children to some other school, private school usually.
Right.
Now, in the past, the Supreme Court has said that when a state sets up any kind of program to benefit schools, it can't automatically leave out religious schools just because they're operated by religious institutions, because that would be discriminatory. This case takes it one step further. It's one thing to say the school is owned or operated by the Catholic Church or Methodists or whatever. What about in this case where the schools explicitly offer religious education? That's the question. That's why this is an interesting question, because it takes it one step further.
Uh-huh.
And many states have, in fact, provisions in their state constitution that say public money cannot be used for religious purposes. So this is the separation of church and state issue, and it's coming closer and closer to public support of religious instruction. And again, you assume that the court took this case because it thinks the lower courts got it wrong. The lower court said that Maine was perfectly fine to restrict this money so it couldn't be spent on religious education. But I think the Supreme Court has been extremely solicitous of religious rights and religious freedom in recent years.
Bill Press with NBC News Justice Correspondent Pete Williams. If you'd like to hear the entire episode, visit BillPressPods.com. And that's all for the America's Democrats podcast. Thank you to all who made today's show possible. Amel Ahmed, John Kowal, and the entire Bill Press team. And thank you for listening. If you liked what you heard, please get involved in our efforts to keep this show going and to elect Democrats who are bringing the party back to its roots. Go to americasdemocrats.org and click on Donate at the top of the page. And be sure to find 21st Century Democrats on Facebook and Twitter, and leave us a review on your favorite podcast app. For the America's Democrats podcast, I'm your host, Jim Cuddy. We want you to sit back and listen, but we need you to stand up and fight. Join us. Support the americasdemocrats.org podcast, a project of 21st Century Democrats, and help elect Democrats who will stand up for democratic principles with your contribution today. Go to americasdemocrats.org and click on Donate at the top of the page.